Hey, everybody. Hope you're doing well. Welcome to my new setup, which is very disorganized at this point. Hopefully, y'all can hear me. I'm trying to make sure that I've got all my text set up the right way. So let me just double check a couple of things while we get started. Can you hear me now? I hope. Give me a thumbs up if you can hear me. All right, guys. Welcome to my new office, my new setup. You can see I have, this side, spots on the wall that need to be patched. There's all sorts of things going on. Tell me, okay, I'm getting thumbs up, so we're getting sound. Good. It has just been a wild couple of weeks for me and for my family because we've moved from Meridian, Idaho to Redmond, Oregon, which is just the next community over from Bend, Oregon. Great to be home, great to see our friends, and the new house is wonderful, but we're still just barely starting to scratch the surface of getting settled in. So I have pictures stacked in my hallways and lots of other stuff that still needs to be taken care of as we nest and get settled in. But I wanted to say hi to everybody because I've missed you the last couple of weeks. I had intended to try and get on live with you on Wednesday, but unfortunately, we didn't have internet. So we finally got internet on Friday, got things a little calmed down, and so here we are. And what did I miss while I've been gone? You know, there never seems to be any shortage of exciting things happening. So first of all, we have a hung jury in Karen Reed's case. And then we have a dismissal with prejudice in the Alec Baldwin case. So I thought we'd talk a little bit about both those cases. I think we'll just go about an hour tonight since we're doing a Saturday night sort of surprise. And I think that we will, by now, you really don't need huge recaps of what's been going on because I'm sure that you've had an opportunity to catch all of those things. I thought we'd just run through it a little bit and then take some questions. So let's start out with Karen Reed. That case, from the beginning, and it's interesting that both of these cases seem to have been cases that were very polarizing. The Karen Reed case was one of those where holy cow, there wasn't much middle ground. It was either you believe that Karen Read was innocent or you believe that she was guilty. There was really no middle ground, except if you were me. Because what I said was, I don't know whether she's guilty or not, but what I do know is that the investigation was so poorly done that I'm not sure we could ever know the truth. There have been a couple of really interesting developments since the mistrial was declared, and those developments have to do with Officer Michael Proctor. He was a state police officer. He has been put on unpaid leave, which is a sort of a precursor to him being terminated. We've also heard that Colin Albert, Brian Albert's brother, has been put on administrative leave as well. I think I cannot remember at this point whether he was a Canton police officer or whether he was a Boston police officer, but he's also been put on administrative leave. Probably the biggest development, if you remember, early on, before the trial really began, the attorneys raised not before it began, but when they gave the jury instructions, that's when it happened. That the attorneys, Alan Jackson and Yannetti, the defense attorneys raised the issue that they did not believe that the jury verdict form was very self-explanatory. We did see that there were a couple of different optional versions of the jury form, and that there was another one floating around out there that appeared to be the standard Massachusetts form that seemed to be a lot more self-explanatory. However, the judge, after modifying her instructions slightly, said, okay, that's good enough, and we're done with that. Well, it appears that we weren't done with that, because it appears what happened was the things that were concerning to the defense attorneys turned out to be the things that tripped up the jury. So following the mistrial, what happened was the jury came back and said, we cannot reach a unanimous decision. And the judge sent them back twice, sent them back once, sent them back the second time after giving the dynamite charge, which is sort of the very stern admonition that they go back and try and reach a decision. Neither one of those things worked, and they came out and said, we are hopelessly deadlocked. So following the judge declaring the mistrial and the jury being released, several of the members of the jury reached out to the defense team and said, we felt we did not understand that we could have come back with a not guilty verdict on the counts that where we were unanimous, and we could have only declared a hung jury on the one count we were undecided on. Now, according to everything we've heard, the murder in the second degree count, they were unanimous in believing that there was no intent. The third count, which was driving under the influence, they found against that. The only thing that they were hung on was the negligent homicide case count. So, but the judge declared a mistrial on all the counts, believing apparently at that point that they could not reach a unanimous decision on any of them. So the judge declared a mistrial. The state announced that the Commonwealth announced that they were going to retry Karen Read. The judge set it out for a status hearing coming up. And then the state or the defense started filing motions saying, wait a minute, something was seriously flawed in the way that the jury decided. Now, looking at it realistically, do I think that the judge is going to grant a reopening of the case based on the allegations that the jury misunderstood the jury instructions? I don't think that's the case, but I do think that it's going to be a serious issue on appeal. And it could very well be that the appellate court comes back and says the jury instructions were flawed and she should have at least been exonerated on the 2 counts that the jury unanimously found not guilty on. So I think we could be possibly looking at that. So Kevin Albert, right? I just saw that in the chat. All these names start running together after a while. There's a Colin, there's a Kevin, yeah. So go ahead and post your questions in the chat for questions that you might have, ongoing questions about the Read case. My understanding is that there are still charges pending against some of the people who were accused of interfering and witness tampering. The guy whose name he goes by Dr. Turtle Boy or something. His name is Aidan Kearney. He still has a case coming up. I still firmly believe that in the Read case, that that investigation was so poorly done that I don't know that we will ever definitively know whether how John O'Keefe died. And I think that's very unfortunate for the O'Keefe family. I saw that they posted or they made some statements after the trial. And as you would expect, they are very disappointed that there was not a final decision and some closure for John O'Keefe. And I think you would expect that from a family whose loved one had been killed, and they don't really have any answers. So while you're working on questions for the Read case, and before we launch into Baldwin, I want to take a couple of minutes and bring you up to date on what's going on the book. So just before I moved, while I was getting ready to pack and all those things, my publisher sent me the very final review of the book before it went to the printer. And she promised me that I would get a clean PDF, meaning one that's not marked up with comments and what have you, to distribute. And I kind of expected I was going to get that last week. However, I got it this morning. So for those of you who are asking, who have joined the book launch team, I will get that PDF out to you. I hope tomorrow I will be doing that mass emailing and you will get the PDF. We are hoping to come up to, we're hoping to get 60 reviews on Amazon, because that will really help the algorithm start pushing the book out to people as a suggested read. So anybody who regularly reads true crime, those books would go out, pushed out. That suggested title would get pushed out to them. So please, please, please if you get a PDF copy, please take a moment and post a review on, at least on Amazon. I will be sending out to you some sort of blurbs and some other reviews that you can use as sort of a guideline, as well as links to all of the places where you can post your reviews. So I'm super excited to finally be able to get it out to you. We're also going to be doing some really fun stuff for the people who are involved in the book launch, some exclusive sorts of content for all of you. And I will be, for anybody who posts a review, I will be sending you a personalized book plate, as well as some other goodies and swag, some stickers. And we will be doing some more personalized content coming up for all of you folks who've so generously offered to read the book early and post a review. So thank you so much for signing up, and expect that it will be in your inbox in the next 24 hours. So, and I appreciate all of these folks who are posting questions about, did I miss it? Where is it? So I love the fact that you are anticipating it. I appreciate that so much. So do we have any read questions, Jen? Hi, Glowing Ember. I'll be watching my emails. What should I watch for? It will come from a website called thegoodlori.com. So that's where it'll come from. And it'll come as a PDF attachment to the email. So good question. Thank you. Hi, Charlotte. If the FBI finds corruption in the investigation by Massachusetts State Patrol and Canton, who would be left to reopen an investigation? Well, if the FBI finds corruption, we don't really know at this point whether it would be some sort of widespread corruption, although I think we know what we all suspect, at least when it comes to the Canton PD. But certainly the state, the Commonwealth, would be responsible for making sure that there are law enforcement officials who will be accountable if the investigation isn't properly done. Here's the tough part about the Karen Read case. Reopening the investigation into how John O'Keefe died and whether or not Karen Read was responsible is difficult, because so much of that evidence was perishable. So much of it was evidence that you can't go back and recover at this point. For example, one of the things that was sort of mystifying to me was why they didn't go out and photograph and laser map the crime scene with all of the shards of taillight, so that they would know exactly where those pieces fell. And an accident reconstructionist, somebody like the FBI experts, or as the internet was calling him, Crash Daddy, because apparently lots of viewers thought he was really good looking. But the FBI crash expert would be able then to say, here's where all of these pieces wound up. We can backtrack back from that and sort of like running a film in reverse and figure out where the point of impact, where they all came from. Now, if you ascribe to the theory that that the taillight was broken in the Sally Port at Canton Police Department and that the pieces were scattered, I think we'd also know that because the expert would be able to say, there's no way that that the force of an impact could have scattered those pieces in that pattern. So that's one thing we'll never know. We also don't know about blood spatter. We don't know about, I mean, there's a lot of things we don't know that cannot go back and be recreated. So I don't know whether reopening an investigation into whether Karen Read hit John O'Keefe is going to be particularly helpful. I think the evidence is what it is. And to be frank, I don't know that that evidence is ever going to point to Karen Read's guilt. So not saying that she isn't guilty. I'm just saying that I think the evidence is very inconclusive at this point. And I don't know how you get around that lack of conclusion in the evidence. So I think it's going to be a little interesting to see what the Commonwealth does. Certainly, it seems to me like the FBI is circling Officer Proctor and perhaps some of the other people who are involved. And I want to say that there are a couple of other investigations that are equally suspect that I think the Karen Read case has drawn attention to. So I think that we're going to see a more in-depth, I hope, look into the corruption in the greater Boston metro area law enforcement. Canton is a small town, kind of a small suburb of Boston. A lot of these people grow up there, live there, die there. And there is that sort of good old boy network sort of feel to it. So I think it's going to be fascinating to see what comes up next. My body is trying to adjust to the allergens in Central Oregon, so I'm pretty scratchy. I apologize for that. Hi, Eileen. Can Karen Read defense petition another court prior to a new trial? If what you're asking is, can they ask for a different judge or a change of venue? Yes, they could do both. Because when there's a mistrial, it is as if they're starting over. Now, interestingly, they can introduce into a second trial evidence, sworn testimony that was introduced in the first trial. So it isn't as if the people who testified during Karen Read's trial could come back and change their story later, because if they did, then the defense would be using their sworn testimony to impeach them. So they're pretty well locked into their statements, into the testimony they gave at trial. But they could ask for a different judge. They could file a motion to change venue, or they could file a motion to recuse Judge Canoni. They could do either of those things. And I expect they probably will. I expect they probably will do both, because Judge Canoni has already heard the evidence in this case and formed an opinion, and has already had interactions with both defense and prosecution during the trial, that both sides could be concerned that she's formed an opinion or formed a bias. So I could see them doing that, and I certainly could see them asking to change venue. I think there were some concerns about whether or not there was a deep enough jury pool in Canton at the time that the case, the first jury was selected. And I can't imagine that it's gotten any less biased because of all of the media coverage and all of the other stuff that was going on. I mean, just from the traffic to the to the media, to the people protesting. I mean, there was so much going on that I think it probably will be doubly difficult to get an unbiased jury in Canton. So I could see them filing a motion to move. I am going to answer this really quick. Because it's my daughter. So I'm just telling her that I will call her later. Because she didn't expect I'd be doing a live tonight, because surprise. So I would expect that they're probably going to file motions to change venue and probably file a motion to recuse Judge Cannoni. Speaking of recusals, we probably want to talk a little bit about the YSL case too, the Young Thug case, before we dive into Baldwin, which was juicy. Because the YSL case has been indefinitely postponed. Now, remember, this case has been going on for 18 months. This jury has been seated for a year. And now they're being told, oh, by the way, after all this time, everything's on hold indefinitely. You jurors, please keep your life on hold indefinitely while we sort this out. It's a mess. You might remember that the judge had an ex parte meeting. That is a meeting with only one side. He had a meeting with a witness, the witness's attorney, and the state, and the defense wasn't invited to the meeting, which was very, very improper. And when the defendant's attorney objected, saying we should have been in that ex parte meeting, the judge didn't want to hear it. All he wanted to hear was, how did you find out we even had the meeting? Who leaked it? It's evident that it was the attorney who was representing the witness. The witness was the state star witness. He'd been granted immunity, then came in and said he was pleading the fifth. It was kind of a mess. The judge called him into chambers. It's very evident that they used some strong arm tactics to get him to take the stand and testify. And when the defense attorney stood up and complained about this ex parte meeting, the judge said, I want to know who told you it happened, and he wouldn't give him that information. And the judge held him in contempt and had him arrested and put in jail. Then there was a whole flurry of activity. The judge revised his motion and said the guy could serve his contempt sentence on the weekends so that he could still be in court during the week. And then they appealed to the Supreme Court, and the Supreme Court issued a stay, a supersedious bond, it's called. So issued a stay. Then they filed a motion to recuse the judge. He refused repeatedly, even though he's very evidently biased. And then later they filed a motion with the Supreme Court trying to get him recused, and he finally agreed to put it in front of another judge within their district. Now, the difficult thing about it is this judge is the presiding or the chief judge, so all the other judges work for him. And so it's sort of awkward to be reviewing the behavior of your boss and trying to decide whether or not he needs to be bounced off a case. So it's very sticky, very dirty, yucky, icky. This is the prosecutors are the same office in Georgia that is run by Fani Willis, who prosecuted Donald Trump. So there's all that sort of overshadowing it, and it's pretty yucky. But it makes for pretty good YouTube. So I'll be keeping an eye on that one. We'll be trying to figure out what comes next for that case. Now, any other questions on the Reed case before we move on? Hi, Jane Blackburn. Any opinion on O'Keefe family bringing a civil case against Reed? This is a good question. Now, usually what happens in these wrongful death cases, going back as far as O.J. Simpson, is the standard of proof for a civil case is much lower than a criminal case. So the way I describe it in lay terms is a civil case gets decided by a preponderance of the evidence. That means 51%. That means the scale tips just slightly in their favor. There is an intermediate standard of proof. It's not super common, but it does come up in things like restraining order hearings and those sort of things, where it is by clear and convincing evidence. I usually put that at about 75%. And then beyond a reasonable doubt, I put at 99%. That means 99% sure that the person is guilty. The reason why we often see civil suits, even if a defendant is found not guilty, is because the standard of proof is easier. So in the OJ case, Nicole Brown's family was able to prove by a preponderance of the evidence they felt that he was responsible for her death. And they got money judgments. But I think it's an interesting question here, because I don't know that they can get to a preponderance of the evidence that she was responsible for John O'Keefe's death. That is a bigger question. I think it's likely that the O'Keefe family will file a civil case, and it will be interesting to see whether or not they're able to prove by a preponderance of the evidence that Karen Reed was responsible for John O'Keefe's death. Now, it could be, it doesn't have to be intentional. It could be negligent. But when you have an FBI agent saying that vehicle did not come in contact with John O'Keefe's body, and John O'Keefe's body never came in contact, the injuries to John O'Keefe's body were not caused by that vehicle. That's a little tougher mountain to climb to even get to a preponderance of the evidence. So, rough and rougher? Why would they retry Karen when the experts say John was not hit by a vehicle? Well, I think this is an excellent question. And we are going to talk a little bit more about this when we get into Baldwin. So prosecutors have an obligation to justice, not an obligation to get a conviction. And so a prosecutor's responsibility is to seek justice. And we're going to see that when we talk about the Baldwin case. So I think that if they do decide to retry Karen Reed, it is going to be a political decision and not a legal one. let's remember that district attorneys, Commonwealth attorneys are elected officials. And so they serve a constituency. And that means that they are looking toward reelection like any other politician. And that really does mean that that it is going to be a political calculation and not necessarily a legal calculation. I think just looking at the case as it was presented in Karen Read's trial, I can't see why a prosecutor would refile it, because I think that the information coming from the FBI was very clear. Now, the Commonwealth walked out of a Karen Read trial and immediately said, we're going to retry her. That sort of, I think that there is at least a chance that the Commonwealth will come back and say, having had an opportunity to review all of the testimony, having had an opportunity to review the way that the FBI experts testified, maybe we won't retry her. Maybe we'll just let the civil side take over. So it will be, that really is going to be a decision that's going to be left up to the DA. So good questions, because boy, if it were me, I wouldn't be retrying her. But, if it were me, I don't know if I would have brought the case in the beginning. Hi, Nana. Has the FBI finished their investigation? Well, this is a good question too. I don't think they have finished their investigation. I think that they have finished their investigation as it applies to Karen Read and the facts of the Karen Read case. That clearly was done before Karen Read's trial started. However, I don't think that they are done with their investigation into the Massachusetts State Police and Officer Proctor. So I think that's ongoing, and I think you're going to see some prosecutions, some federal prosecutions in that FBI investigation. So yes, they have finished the portion of it that has to do directly with Karen Read, but Trooper Proctor's, the impact that Trooper Proctor has on cases in Massachusetts goes well beyond that. And I think we could see the FBI going back and wanting to take a look at other cases that Trooper Proctor's been involved in. Yeah, because that's pretty far reaching. So good questions. Well, y'all ready to buckle up, because we're going to talk about Baldwin. So first of all, I want to say, when I watched the Hannah Gutierrez Read trial, I didn't love this prosecution. Morrissey is her last name. I wasn't impressed. I thought she was pretty arrogant, pretty. I didn't like the way she talked to the judge, and I do understand cross-examination, and part of a defense attorney's job or a prosecuting attorney's job is to sometimes go to witness into saying things on the stand that the other side doesn't want them to say. So I get that completely, but I thought that Carrie Morrissey a lot of times was not, what her behavior really went beyond what I would classify as defense or prosecution tactics. And it was bothersome. I didn't like the way that she treated witnesses. I thought she was very condescending. And I came away from that trial thinking, I really don't like her. That said, I watched that motion hearing that morning. I was watching the trial, and I watched the whole thing, and I came away feeling just a little bit sorry for her. First of all, I thought that Alec Baldwin's attorneys did a really good job. Alec Baldwin could afford a team of attorneys who literally combed through every sentence of every report of every and that is a luxury that most defense attorneys simply don't have. You know, our time is sometimes so compressed and so pressured that defense attorneys don't necessarily have the time and the luxury to really take apart and reassemble all the evidence. So they were doing a very good job. Now, there were a couple things that I thought they didn't do such a great job on. And the day before, they had been really thrown off by the fact that they believed the judge had ruled that Alec Baldwin's statements were not coming in. It turned out that she said, no, you misunderstood my ruling. His statements do come in, but the state cannot make the argument that as a producer, he had some sort of heightened duty, heightened responsibility. He's only being tried as Alec Baldwin, the actor, not Alec Baldwin, the producer. And I'm not going to let in any information that could suggest that he had a higher duty because he was a producer on the film. Now, I want to say this. Producer credits, when somebody's trying to make a film, I was approached by a group that wanted to make a documentary from my book. And one of the things they offered me in sort of in compensation was a producer credit. And the producer credit was because I was the person who had the contacts and knew all the people and knew the story. I wasn't going to be doing specific producer duties, but I would be helping with the script and helping do all those other things. Unfortunately, they didn't realize that Netflix was doing Sins of Our Mothers. And once that came out, they sort of dropped the project. But I was offered a producer credit along with monetary compensation. I was offered producer credit, which means that I would show up as an assistant producer on the movie. So there are often times that members of a production staff end up being producers that really, it recognizes their role in the movie, doesn't necessarily mean that they are the person on the ground producing. And there are many roles for producers. So, my goodness, if you're hearing that, that's my garage door, and it's right under my office. So now we know that when the garage door opens and closes, it's very noisy in my office. All these new discoveries that we're having. So anyway, the fact that Alec Baldwin was a producer had more to do with his Hollywood contacts and his ability to raise money to get contributions, to get investors in the movie than it did with any really hands-on responsibility. Hello. Yes, my little dog's here. Can you see her? There she is. That's Bindi. Okay, get down now. So the state, the judge ordered that they couldn't bring in the argument that somehow that as a producer, he had some sort of heightened responsibility for safety on the set. So, and there was a certain sense that the defense was sort of taken aback a little bit by the fact that the judge said, no, his statements are going to come in. You just can't link it to him as a producer. So the next morning rolls around and the defense has something they want to bring up to the court. So now I want to point out that the defense in the Gutierrez trial raised the issue of discovery. And this Alec Baldwin's team has raised this issue of them not disclosing everything before. And as you saw in the Lori Vallow case, the judge threw out the death penalty because the state messed up and didn't give the defense everything that they were obligated to give them. Now, there's always this tension, and it comes up in just about every trial where there are discovery issues. So the defense says, you didn't give us everything. And the prosecution says, well, we're not obligated to give you things that we don't think are relevant to the case. And there's always this sort of tug of war going back and forth about who decides whether this is relevant information or not. Because what the discovery statute says is that they have to turn over everything that could potentially lead to exculpatory information, meaning information that is favorable to the defense, or that could be used as impeachment against witnesses for the state. So that is a really broad net. I mean, you can make the argument that just about anything could be used for impeachment or could lead to information that could be used to impeach someone, or could lead to information that could be used to exonerate them. It doesn't mean that it has to. It just means that the standard is it must lead to that kind of information, only that it could. So it's a very broad net. And there's nothing that frustrates a defense attorney more than for a prosecutor to stand up and say, oh, it's not relevant, so you don't get it. Or we don't plan to use it, so you don't get it. And neither one of those things are true. But prosecutors try and pull that little game often. So what happened with Baldwin was the defense came in and said, we have reason to believe because of our investigation, not because of anything you gave us, but because of our investigation, we have reason to believe that there is information that could, at a minimum, be used for impeachment and potentially could be exculpatory. And the prosecution kept saying, we've turned everything over, we've turned everything over, we've turned everything over. Well, that was sort of a loose interpretation of turning everything over, I guess. So here's the way I understand it. And the testimony was pretty complicated and there was a lot of moving parts to it. So when the police went out and served the search warrant and collected all of the evidence having to do with the set of Rust, they confiscated, they took into evidence all of the rounds that were on the set, all of the bullets and shell casings that were on the set. Now, you heard testimony that there should never have been live rounds on the set. And everything was pointed very firmly at Hannah Gutierrez Reed, that she was the one who brought those live rounds onto set. So later, they went to the prop house. That was PDQ Props and Guns. Okay. This is the guy who, he was not the armorer, he was the prop guy. He provided all of the props for the Rust movie. He was also providing props and guns for the Yellowstone 1883 movie. And so during that period of time, he was moving props around. Now, the way it was explained was there are two different kinds of rounds that should end up on a movie set. One is dummies and one is blanks. Okay. Dummies are rounds that look like a live bullet, and they are put into guns for close-ups, so it looks like the guns are loaded. Those dummy rounds have a projectile on the end of them, but they have no gunpowder in them. And they put inside those rounds a BB, so that when you rattle it, you can hear it rattling around. When you shake it, you can hear that BB, like a paint mixer in a paint can. So the other thing, that the other round that potentially can be on a set, are blanks. These are bullets that have no projectile, but do have a gunpowder explosion and a primer. Okay, so they do have gunpowder and a primer, so they make a bang and often produce smoke. Usually there's a wadding in them, generally something inert like paper. So those were the two things that should be on the set. But Seth Kenney, who was the PDQ prop guy, he and Hannah Gutierrez Reed's stepfather, whose name I think is Thale Reed, they were also providing education for actors on the set, and they were going out to a range and having the actors fire live bullets so they would understand the weight of the gun, the feel of the recoil, all of those, that mechanism, the actual physical mechanism of cocking it, pulling the trigger, all of those things. So they were doing what they called cowboy camp. So they were taking these groups out to a shooting range. They were taking the folks from 1883 out to the shooting range. And so Seth Kenney, who PDF props, and Thale Reed had a green ammo can that they had live ammunition in. So there was a lot of discussion, and this is where it got sort of confusing and a bit in the weeds. There was a lot of discussion about what did and didn't resemble the live rounds that ended up on the Rust set. So my understanding is that they were a specific brand of Sky something brass. They had a silver primer, and they were supposed to be blanks or dummies. So all of the dummy rounds that were on the set had a different primer. The upshot to the whole thing is, during the Hannah Gutierrez Reed trial, Another man who had been involved with these cowboy camps or cowboy shooting schools reported that he had live rounds that looked just like the dummy rounds that Hannah Gutierrez had on the set of Rust. He brought them to the courthouse during the Reed trial, and the investigator on the case, the main investigator, was involved in the trial and told the court security, I'll come down for him later, but I can't come now. I'm in the middle of trial. And so the guy got tired of waiting and he left. And he then went to the sheriff's department and he gave a statement and he turned in these bullets. They were live bullets. One of the things that they pointed out was that the live bullets didn't look anything like the dummy rounds. And so they then were saying this was all Hannah Gutierrez Reed's fault because she should have known that these were mixed up. The dummy rounds and the live rounds didn't look alike. However, the live rounds that this guy turned in and said were part of the ammunition that was cycling in and out of these cowboy camps looked just like the dummy rounds. And it would have been easy to get them confused. So what this does is it casts some doubt on Hannah Gutierrez Reed's conviction. There goes the garage door again. Gonna have this conversation. Anyway, so the judge started to take testimony. Now, what the officer who received those rounds during Hannah's trial said was she received them, she put them into evidence, but she was told to put them into evidence under a different, not under the Reed and Baldwin case, but under a different case number. Now, this does sometimes happen, particularly when the case has been going on a long time and the case is in a different posture than it was at the beginning. But what should have happened was that a supplemental report should have been issued into the Baldwin and Gutierrez Reed case, referencing that evidence. That connection never happened. So when the defense went and said, we want to see all of the physical evidence from the Baldwin case, those bullets didn't get pulled and they didn't know they existed until the same guy who brought in the bullets then said to the defense, hey, did you ever see those bullets I brought in? And they were like, what bullets? So they brought it up at trial and filed a motion saying that they wanted the case dismissed because of this glaring Brady violation. Let's face it, I'm not sure that it had as much impact on Alec Baldwin's case as it did on Hannah Gutierrez Reed's case because of the fact that it did indicate that she could have mixed those up. They looked alike. But I don't know that it had a tremendous amount of impact on Alec Baldwin's handling of the gun, except that it was a huge, huge violation of the prosecutor's obligation to turn over evidence. It's unclear whether they would have been able to use that information on behalf of Alec Baldwin. I don't know. But the fact that that huge violation happened was enough for the judge to dismiss the case. So the biggest problem was that during that testimony, early in the case, Carrie Morrissey, the prosecutor, she is a special prosecutor. She was appointed. She is not part of the district attorney's staff. She was a defense attorney who was specially appointed to prosecute the case. So during that motion hearing, while they're talking about the evidence, Carrie Morrissey says, that the defense attorney says, I've never seen this report. I've never seen these bullets. She says, I've never seen them either. This is the first time I'm seeing them too. Well, now what would you think when you hear that? You're thinking, okay, this is something that the prosecutor didn't know was out there either. Now, prosecution is supposed to know what's out there for evidence in their case, but she pointed out there were thousands of pages of evidence. There were hundreds of physical exhibits and evidence that was seized. And so maybe if it was actually booked in under a different case number, maybe she didn't know. So then as the hearing goes along and they start questioning some of the law enforcement, they question Detective Hancock, who is the lead detective on the case. And she says, we had a meeting where we discussed this evidence, and Carrie Morrissey, the prosecutor, knew that we were logging this in under a different case number, that it was not being logged in the Baldwin case. She knew that. Had she seen the actual police report that went along with it, that documented when they were turned in? Apparently not. But she knew that they were there. And so she misled the court by saying, well, I've never seen this report before either. She may not have actually seen the written report or held the bullets, but she knew about them. Her testimony was that initially, when this guy said he had bullets, he was in Texas or Arizona. She asked him to send her pictures. She looked at the pictures and said, these rounds don't match anything that is in the case, so we don't need to produce them. And that she didn't believe them, and that what he turned in was different than what he sent her pictures of. That's what she says. So the interesting thing is that during the time that this hearing is going on, there was a second prosecutor. She had just been appointed in April as the second chair for this case. And that prosecutor asked to approach and told the judge that she was ethically obligated to ask to withdraw, and left the courtroom because she believed that Carrie Morrissey was being unethical. So that attorney withdrew, the judge allowed it, and she withdrew and left. So ultimately what happened at the end of it was the judge declared she dismissed the case for prosecutorial misconduct and ordered the dismissal with prejudice. Now, there are two ways a case can be dismissed. It can be with prejudice or without prejudice. And we saw that in the Baldwin case, because you remember that initially Alec Baldwin was charged. And then when it became clear that the FBI had damaged the gun beyond restoration, that they dismissed the case. that was dismissed without prejudice, meaning they could refile it. And of course, they did refile it. However, the judge decided that this was such an egregious violation of discovery rules and ethical obligations that the judge dismissed it with prejudice, which means it cannot ever be refiled. One of the reasons for that has to do with double jeopardy. Because once a jury is sworn in, jeopardy attaches. Now, in the case with Karen Reed, where the jury could not reach a conclusion and the judge declared a mistrial, that can be refiled. But in this case, the judge said jeopardy attached at the time that the jury was sworn in, and the fact that the case did not reach a conclusion wasn't because of the jury, it was because of the prosecution. And for that reason, he can't be retried. It's kind of a fine line, but in general, once jeopardy attaches, the case has to be dismissed with prejudice. The exception is if the case is declared a mistrial because of a hung jury, then the charges that the jury could not reach a conclusion on can be retried. So hopefully that explains that. In spite of the fact that that the prosecutor in this case committed a horrible, horrible ethical breach, I still couldn't help but feel sorry for her. Maybe that's just my defense attorney heart and knowing what people put into these kind of cases, and knowing the fallout and the things that were coming her way. I just couldn't help but my heart go out to her a little bit, because she's in for a really rough road. So Alec Baldwin obviously was incredibly relieved, and I thought his lawyers did an excellent job. I mean, that's what you get when you have lawyers who can devote the kind of time that it takes to be that fluent in both the law and the facts of the case. Because that's what it takes. Unfortunately, for those of us who do public defense and are carrying crippling caseloads, it is an impossibility to be able to devote the kind of time and resources to knowing your case inside and out that Baldwin's attorneys were able to do. So shall we take some questions? I see a few starred questions coming up in the chat. So let's see what you all have to say about the case. Hi, Polio. How did Alec's defense find out about the other evidence, different case number bullets, to even ask the witness about it? Well, this is a good question. My understanding is this third guy, whose name really escapes me, he was the Good Samaritan, they called him, the guy who showed up actually at the courthouse and tried to turn the bullets over. My understanding was they had his phone records, and they, as most defense attorneys would do, interviewed all the witnesses, and they interviewed him. And he said, hey, what'd you think about these bullets? Didn't they look a lot like the dummies? And the defense said, what you talking about, Willis? If you're old enough to remember that, you're old like me. And I think that was the way it was discovered. You know, defense attorneys have their own investigators who go out and interview witnesses and talk to people. And that's how we turn up that kind of information. And they knew that the prosecution had at best overlooked it, at worst buried it. So, good questions. Any other questions about the Baldwin case? Juliana, can I mail an excruciating evidence to detectives if I ever get charged with a crime? Good to know. Exculpating. Okay. Exculpatory information, absolutely you can and should point out exculpatory information if you are charged with a crime. You absolutely should be presenting that evidence to show that you had an alibi, that you weren't in town when it happened. Here's the receipts, those sort of things. Yeah, you should be. And it actually wasn't Alec Baldwin or anybody else associated with him. It actually was someone who was associated with the prop company and the person who provided the prop guns and the dummy rounds. You know, I think this is a really good example. I think if you watch the trial, you could see the prop house looked like a hoarder's house. How you would ever be able to tell where things were and what things were. I mean, that was, I don't know how they ever found anything in that place. And it's in that environment that you run the risk of commingling things that have no business being commingled. And to me, he had no business ever having live rounds on his property at the prop house, because that was just asking for trouble. They should never have been located. He should never have live rounds on that property, not when you're dealing with dummy rounds and blanks. So it seems to me they should have been, any live rounds should have been stored off his premises. But he was involved with the two other guys, Hannah Gutierrez Reed's stepfather and his associate, who was the guy who turned in the bullets. They were involved in this cowboy camp where they were shooting. And I suppose there's sort of a gray area where things sort of overlap, because the prop guy, he's got real guns that are being used as props, and they're being fired, used in live fire kind of practice exercises on how to use the gun and how it's going to feel when it actually fires. So I suppose there's some overlap there. But it does seem to me like he shouldn't have had anything to do with live rounds if he's supplying dummies and blanks. So I expect that there's going to be a lot of re-examination of security, re-examination of procedures in the wake of this. The same way there were in other movies where people died. There was it came out at trial that there was a fellow who was an extra on the set and took a gun that was loaded with blanks and held it to his head and pulled the trigger. And even a blank can kill you at close range. The other one was on the set of the Crow quite a few years ago, and that was a case where blanks were improperly built, and there was some sort of debris either in the gun barrel or actually in the blank round that acted as a projectile and killed an actor. So I think that was Brandon Lee. That was Bruce Lee's son. So, you know, I understand the people, and, you know, my husband's one of them, who grew up handling guns, and who will tell you that you should always presume and treat a gun as if it's loaded. And I think that that is important wisdom that needs to be pointed out. The problem with that is when you're on a movie set and you are acting with guns in a way that to make the audience believe that you are using a live gun, it's not always possible to treat that gun as if there's a live round in it. So I do understand that. I also understand that there was a procedure in place. The armorer loaded the dummies in the gun. The second assistant director's responsibility was for the security of all those guns. His responsibility was to take every one of those dummies out and shake them and put them back in the cylinder. He did not do that, which is why he took a plea and pled guilty to negligent homicide. So there is sort of a tension between you're always supposed to treat a gun as if it's loaded, to, but was it foreseeable that on a movie set, in the middle of blocking the movie and shooting these scenes, that Alec Baldwin, did he have a right to rely on the process and rely on the report that he was being handled a cold gun? He was handed a gun and told the gun is cold, meaning that there were no live rounds in it. So did he have the right to rely on that? And was it foreseeable that if he pulled the gun and pulled the trigger, that it was going to kill someone? I still come down on the side of, I don't believe that it was foreseeable for Alec Baldwin. Was it foreseeable for Hannah Gutierrez Reed? Absolutely. She had one job. That was to make sure live bullets did not get into cold guns. The associate director, Dave Hall, was it foreseeable for him? Absolutely. He had one job. That was to make sure that live rounds did not get into a cold gun. So I believe both of them had culpability. The question then is, did Alec Baldwin also share some culpability? I have a hard time from the legal perspective, okay? Not from the moral perspective, not from the gun handler perspective, but from the legal perspective, the definition of foreseeability and the definition of negligent homicide in New Mexico. I have a hard time making that connection. So, other questions? I see some questions in the chat. Have you ever seen a prosecutor take the witness stand and be cross-examined by the defense? No, never. Not in 30 years. I did see one instance in all of my time of a lawyer being called after the fact to testify about something that happened while the case was underway. Even that was very unusual, and it had to do with whether or not an issue could be raised on appeal. And that was the only time. But I have never, ever seen a prosecutor take the stand. Clearly, she cannot be, not that they would ever ask her to be a prosecutor again, but she can't continue to prosecute anything having to do with Gutierrez Reed or Baldwin, because she's now become a witness in the case. So if Hannah Gutierrez Reed is able to secure a new trial based on her misconduct, it's possible that the DA could be called as a witness by the defense to show why she should be getting a new trial. So, but no, that was unheard of. And I want to point out that it was very important that the judge and the defense both said, we don't believe you need to take the stand. We think there's been enough evidence already to support a mistrial. Both the judge and the defense said, we don't think it's necessary. But she wanted to get on the stand because she felt like she needed to explain herself and perhaps defend herself. I mean, ultimately, I think what they did was indefensible. And if she didn't know, she should have known. And there was ample evidence that she did, in fact, know that those pieces of evidence were being logged in as a different case number. So I think that she has a lot more coming down on her. This is only the beginning of the consequences to that choice. Hi, Jen. What is your opinion on Gloria A? I'm assuming you mean Gloria Allred. Do the parents have a case if the husband settled with AB? Oh, Alec Baldwin. Okay. Duh. So Gloria Allred, Gloria Allred has done a lot of good for a lot of victim families. And I think that we would not have the light shining on victims' families if it weren't for Gloria Allred. And she has been doing this a long time. And she has made a lot of money representing victims and their families. I don't know how I feel about that. On the one hand, it seems kind of like ambulance chasing. It seems a little icky. On the other hand, I think that she has served a really important purpose in drawing attention to the families of victims. I think that she gave Lacey Peterson's family a voice. She's given voice to a number of victims and their families. I think that she was involved in Chris Watts, that case. So, I mean, I guess I feel a little ambivalent about Gloria Allred in general. I do think that there may be wrongful death suits to be had, even if the family has settled with Alec Baldwin. But a lot of that is going to depend on the terms of that suit and that settlement, whether or not that fully satisfied any claims that any of the other co-defendants might have had. So since I don't know how that settlement was drafted or who it included, I think there could be some other suits that could be coming out having to do with what happened on the scene of Rust. Helena Hutchins' family could, I don't know whether or not I know that they brought a separate action against the production company that was filming Rust. And I know that they may very well have also brought a separate suit against Hannah Gutierrez Reed. Whether or not she had anything that they could go after, I'm sure that she would have to have some sort of liability insurance to serve as the armorer, and I'm sure that they probably have gone after that as well. So A lot of it is depending on whether or not the settlement that they made with Alec Baldwin also settled all the claims having to do with the other victims and the other defendants. Can Hannah's case be overturned now because of the dismissal? I think this is a very good chance. I think that there is a very good chance that she could file a motion for a new trial based on the new evidence. And I think that there's a chance that she could be retried. The court could grant that. If the trial court says, no, we don't believe that that this rises to the level of new evidence because your attorney actually knew about this evidence, because the prosecution says they knew. I think it may very well be a basis for the appeal to throw out her conviction and give her a new trial, the appellate court. So I think either way, she may very well get a new trial. Hi, Auntie Mom. The second prosecutor said she quit because Carrie didn't dismiss the case in the morning. How would things have been different if she had just dismissed versus having a public trial on the motion? Well, this is a good case. She would not have been publicly raked over the coals. Carrie could have gone to the judge and said, Judge, I've been made aware of the fact that there was potentially exculpatory evidence that was not turned over to the defense, and I do believe that it warrants a dismissal. And at that point, she probably would have dismissed it with prejudice because the jury had already been impaneled. And all of her dirty laundry would not have been aired in court. That's not to say that the judge and the other attorneys may not have said, this was a serious ethical violation, and we want to talk about whether or not you should be reported to the bar, or that there should be a disciplinary action through the state bar. So there could have been other consequences, but it would not have all been, all the dirty laundry would not have been drug out in public. And the second prosecutor said she told Carrie that Carrie needed to dismiss the case, and Carrie declined. I don't know why, because the smart prosecution would have been the smart move would have been to dismiss the case before all of that conduct, that questionable conduct, got aired in public. So, good question. What is your opinion on the set medic filing claims? Why would she take a medic job if she can't handle trauma? Well, let's think about that. Yes, she was a set medic. Yes, she was a first responder of some form. Some sort of EMT. So she was trained for that. But let's really think about what the set medic does on a daily basis. They're worried about, did somebody fall down and scrape a knee? Is somebody out in the heat too long, and do they need hydration, and are they getting heat stroke? Do we need to make sure they're all wearing sunscreen? Do we need to make sure that they're that they're safe while they're walking across the set? What happens if somebody trips over a power cord and bumps their head? These are much more likely to happen than to have someone take a bullet to the chest. And I can see how that could be exceedingly traumatic. Now, I'm aware of a case in Bend, Oregon, where two police officers. Now, police officers are trained to return fire. They are trained to respond with guns to a criminal act that puts their lives in danger. And yet I know of a very experienced Ben police officer who was involved. He wasn't even the officer who was involved in the shooting. He was the other officer's backup. And they did a traffic stop. It was late at night in downtown Bend. The guy was acting like he was under the influence. And when the guy opened the door, the other officer believed he saw a gun, and he shot and killed that man during a traffic stop. The other officer was so traumatized that he could never go back to work as a police officer. So we don't know the impact that seeing something like that, experiencing something like that, is going to have on someone. For example, and I decline to get political, but there was a potential assassination attempt on former President Trump while he was at one of his rallies. The gunman opened fire. He got off several shots, including one that grazed former President Trump's ear, and there were rounds that hit people in the crowd behind him, including one person behind him who was hit in the head and who was dead on the scene. The first responders, including an emergency room physician, they were all there on the scene attempting life-saving to give life-saving treatment to both him, the person who died, as well as several other people who were injured by the gunfire. And we don't know how that is going to impact you. You can train forever, but you don't know how that is going to impact you until it actually happens in front of you. So yes, I think that the set medic probably was trained, but had probably never experienced something like that before. To have two people in front of you who are badly wounded and very likely dying, and it's in your hands to try and perform whatever life-saving measures you can to keep them alive until they are airlifted to the emergency room. So while it's easy from our vantage to say, hey, you're trained to handle these kinds of things, I don't know if you really know until you've been there what that's going to feel like. So good question. I think that set medic was probably a lot more prepared to deal with sunburns and bee stings and cuts from a knife or something like that. I don't think that set medic was ever ready for that. Hey, Teresa Moore, is the investigation into the Massachusetts police or the DA office? I think what you're asking is there still an investigation going on in the Karen Reed case, investigation into the Massachusetts State Police or the DA's office? I'm not sure the DA's office warrants an investigation in the Reed case, but certainly the law enforcement agencies that were involved, the Canton Police Department, the Boston Police Department, the Massachusetts State Police certainly have been under investigation. And I believe that the FBI investigation into the Massachusetts State Police is much more far-reaching than just Karen Reed or just Trooper Proctor. I believe that it goes well beyond either of those situations. So Trooper Proctor is on unpaid leave and very likely going to be terminated. However, it has to go through the proper channels because they're all members of the union. So they have to observe the proper steps before he can be terminated. And I'm certain that they are looking at any other cases that he was the lead investigator on, which could open a real can of worms, because they could be going back and having to retry or reinvestigate and re-prosecute cases that he was the lead investigator on as well. So these are good questions. And we have managed to fill an hour and a half. Gail Swift Fernandez, in the judge's direction, she said, come back when you've reached a verdict on all the charges. That is confusing if the jury could decide 2 of the charges. I agree. I agree that the instructions that the judge gave the jury were confusing. And while that was going on, I looked at the jury instructions. In every state, there is a standard set of jury instructions. They're usually developed by a committee that includes judges, prosecutors, and defense attorneys that all come together to write those. And they also create proposed jury verdict forms. And in looking at the standard proposed jury instruction or jury verdict form, as opposed to what was given to the jury, I could see that the other one was much more clear. And the second count that had to do with some lesser includeds and whether or not these other things applied, I could see very much why they ended up being hung on that charge. And the judge did instruct them to come back when they had a verdict on all the counts. She at no time instructed them that they could find not guilty on some counts and come back deadlocked on other counts. So I agree that her jury instructions were not clear, and that it very likely led to this outcome, the jury being hung. The question is, what's the remedy at this point? How do you fix it? Do you call the jury back in? Does the judge say, I'm going to find her not guilty on the 2 charges the jury was unanimous on, and I'm going to only declare mistrial on the charges they couldn't reach a verdict on? And how do you account for the fact that the jury has been watching the news and been talking to the media and all of those things ever since? How do you account for that? How do you ensure at that point that you don't have jurors that are later coming back and saying, oh, well, now we're saying that that's what happens. So it's a thorny issue, and it could have been avoided had there been a good jury instruction, which there wasn't. So I think it's unlikely Judge Cannoni is going to come back and say, I'm going to issue a finding of not guilty on the 2 charges the jury was unanimous on and let them retry the one that they were deadlocked on. I think more likely it's going to be an appellate issue, and the appeals court's going to give her a new trial. So I noticed that Jen has some information up in the chat about the crane quilt that we're making. We are making a origami quilt squares to put into a quilt for Kay and Larry Woodcock. The pattern, the link to the pattern is in our show notes. I did have somebody say they had trouble downloading that and asked me if I would mail them a copy of the pattern. I'm going to do that. I do have a few Justice for JJ and Tylee wristbands left. If you have sent me a request, I will get those out. And I do not have a new address. We've taken the address down that was in the show notes for both the quilt squares and the bracelets, because I need to get a new PO box. So we'll be getting that up in the chat and distributing that through the Facebook group very shortly. CRIMECON 2025 is going on in Denver in 2025.
You're not on, are you?
Yes, I am.
Hmm?
Yes.
I thought you started at 6.
No.
Sorry.
CRIMECON, my husband just thought I started at 6 instead of at 4. So CRIMECON 2025 will be happening September 5th through the 7th in Denver. Remember that although a lot of people find the tickets kind of steep, they love volunteers who help direct traffic, and it gets bigger every year. So they need more volunteers every year, and you get a ticket to the event if you volunteer. So that is also a possibility if you happen to be in the Denver area. I've already made my reservations and booked my chance to go. And so I hope that you all will be joining us. I do have a Facebook group that covers what's going on in my world, my newsletters and all those things. It is The Good Lori. So thank you all for joining us tonight. We have time for a couple more questions. If you've got any more questions about Baldwin or Reed or any old thing, I'm happy to answer those questions. And if you have questions we don't get to, please post them in the comments. I do read those, and I do read the show comments usually within a week or so after we do a live. So I'm going to give you a couple more minutes to see if there are any other questions coming up. Let's see what we have coming up this summer. We have Donna Adelson's trial coming up this summer. Lori Vallow's trial was set over until February of 2025 over her objections, which I think is really, really interesting. If you recall, she refused to waive her speedy trial rights in Idaho. And it wound up, because of all of the delays and her competency issues, she wound up being 41 days outside of the speedy trial window. And I think that is going to be an appellate issue for her. I really need to dive into the law in Arizona and how the judge gets away with setting her trial out over her objection because she refused to waive her speedy trial right. I realize that her attorneys were fairly new to the case, and that there are thousands and thousands and hundreds of hours and thousands of pages of discovery that they need to go through. However, she objected. So it's going to be interesting to see how the court justified that. Once again, if you're part of the book launch team, I got a clean PDF today, and I will be mailing that out to the 106 people who are on the mailing list. And I will be sending those out. I will be rewarding oh, this is a good question. I'll answer it in just a second. I will be rewarding those of you who post reviews with personalized book plates and some other swag. And I will be posting some exclusive exclusive content that I'm going to be creating for those folks who are involved in the Book Launch League. So please look for your PDF. It should come from thegoodlori.com. and look for your PDF in the next couple of days. If you have not gotten yours and you signed up for the Book Launch League, drop me an email and let me know. It may be, check your spam folder, it may be there, but it may have also bounced back. So be sure and let me know if you signed up and got a welcome email and have not gotten the PDF, because I want to get as many eyes on it as we can. Is Karen still on bail? Well, that's an interesting question. Because of the mistrial, the case was not dismissed the way it was for Alec Baldwin. Okay, the case was not dismissed, and so she can be retried on the same indictment, and that means that the same bail terms apply. So yes, she is still on bail. Or whatever the terms of her release were initially, she's still subject to them. So I'm assuming that she posted bail. I don't remember what the terms were of her bail, but they would still apply because the case was not dismissed. The mistrial was ordered, but that is different than Alec Baldwin's dismissal. His dismissal completely gets rid of the case permanently as it applies to him, having to do with the death of Helena Hutchins. But in Karen Reed's case, the judge declared a mistrial and ordered that a mistrial was declared, but she didn't dismiss the entire case the way they did in Baldwin. So hopefully that clarifies that question. No question, but I miss seeing you. Glad you're back. Thanks. I missed all of you. I missed getting a chance to chat with all of you and to talk about what's coming up. Definitely, we've got some interesting cases coming up over the summer and fall. We aren't going to see Brian Koberger until next summer, but we are going to see Donna Adelson, and we are going to see, who else are we going to see? Come on, help me out here. There's one other one, and now I can't remember. So, but definitely we're going to see Adelson. That one's going to be fascinating. Oh, Allen. Yes, I'm sorry. Richard Allen, of course. Delphi. Yeah. So those are the things that are going to keep us busy this summer. Unfortunately, in Delphi, the judge has continued to deny cameras in the courtroom. So we are not going to see that. At this point, she is not even allowing transcripts. And yes, we do have Sarah. Okay, now my brain is presently Boone. Sarah Boone. Thank you. Thank goodness for Jen. Yes, we will see Sarah Boone because we've been told she is going to have to act as her own lawyer. I think that one's set in October. So we have Sarah Boone, we have Richard Allen in Delphi, and then we have Wendy Adelson coming up. Now, I do want to tell you that it doesn't appear that Judge Francis Siegel is going to allow cameras in the courtroom in Delphi. And that is going to make people who are covering it from the courtroom really, really valuable. And that includes Bob and Ali Mata from Defense Diaries. Bob will be traveling to attend the trial. You might remember he's in Illinois, and he's planning to be in Indiana for the trial of Richard Allen. So we're going to see that one through the eyes of Bob, who is a defense attorney. And Ali will be giving legal analysis, I think, from her home. So they'll be double teaming that one. But if you are not subscribed to Bob, you should be. His site is YouTube channel is Defense Diaries. The link is in our show notes. He also has a really fascinating podcast. His father was a defense attorney and represented Gacy. And when his father passed, he gave Bob all of the tapes that he made of all of his interviews with John Gacy. And so Bob has been doing a podcast series called The Gacy Tapes. So if you're interested at all in that, in Gacy, he's the guy for that. So please do. We also do have Stephen Stearns coming up, although I don't know that a firm trial date has been set in that case yet. I know that a trial date has been set, but whether it is firm and whether or not he's going to waive his speedy trial, I think it's a little too early to tell on that one. That one's that one is another one that is going to be tough, kind of like Harmony Montgomery. That one's going to be a real tough one because it involves child essay and murder. So, well, y'all, we managed to fill 2 hours or just about. So thank you so much. I missed all of you. I am looking forward to getting back into the routine. You can look for our regular True Crime Wednesday starting next week. So if you have not subscribed, please like and subscribe on your way out. It definitely helps us out. And I'm just want to let everybody know who has pre-ordered the book about the Lori Vallow and Chad Daybell case, that the release date, because Chad's trial running late, slipped to September 24th, but that is a firm date. So you will see and be able to hold in your hands your copy on September 24th. If you would like a personalized book plate, once I have made sure that all of my folks who were part of our book launch group get theirs, I would be happy to send them out for a self-addressed stamped envelope. And I will have a new address for you, I hope, by Wednesday. So thanks again for joining me. I know that you could spend your time other places. And today was a surprise live, so we didn't have quite as many people in the chat as we always do. But thanks for joining me, and I will see you on Wednesday for another installment of True Crime Wednesday. Good night, everybody.